Welcome once again to Lehto's Law. Here's Steve Lehto.
I've got a story here that I've been waiting to see what would happen before I did a video about. Had a lot of people ask me to do this video, and so I'm going to do it now because I think we've got enough happening to where it makes sense to do it. Young thug trial. Rapper's lawyer won't go to jail after Georgia Supreme Court grants bond. And so this is a crazy case. It's a crazy case. Fox 5 Atlanta has been following this very, very carefully. This is their version of the story. And basically, I'm going to summarize for you what's happening. There is a trial, and the defendant has an attorney. The attorney discovered that the judge had ex-parte communication without him, the defense attorney, present. And now that would appear to be improper. And when he brought that to the judge's attention, instead of saying, "Oh, let me explain that," the judge said, "Who told you?" And he said, "I'm not going to divulge that at this moment." The judge goes, "You better divulge it or I'm going to hold you in contempt." The attorney said, "Ain't going to do it." So the judge held him in contempt and threatened to throw him in jail. And so what happened then following is a bunch of legal wrangling. And we're going to talk about this because it appears that the judge is 100% wrong. And there's a reason for that. It has to do with the rules that judges are supposed to follow. And yes, there are rules for judges. So out of Fulton County, Georgia, the attorney for the Atlanta rapper Young Thug, his name is Brian Steele, the attorney, will not have to spend time in jail because although he's been found in contempt of court, the Supreme Court of Georgia granted his emergency motion staying the judge's order that had held him in criminal contempt. Court also agreed to hear that case at a future time because, of course, there's a trial going on right now. So until that appeal is completed, the court will allow him to remain out of custody. So the judge had ordered that Steele be taken into custody after Steele approached the bench following the lunch recess, revealing his knowledge of an ex-parte communication that took place before the court earlier that morning. An ex-parte is one of those Latin terms that basically means roughly from one party or by or for one party. And ex-parte communications are not good. They're something that you learn about in law school, and judges know this. A judge cannot meet with one side of a pending case and talk to them about the case. Now, don't get me wrong. If you're walking down the street and you see the judge, it's a weekend, and you're not in court. "Hey, judge, how you doing?" You can wave and say hello. You don't stop and talk about the case. In fact, you don't even stop and talk about anything for fear it would give the appearance of impropriety. So if the judge did, in fact, talk to a witness or the prosecutor without the defense attorney present, that would be a problem. And so when the attorney brings that to the attention of the court and the court goes, "Who told you?" that's the wrong question. Instead, the judge should be saying, "Oh, let me explain." But I don't think he ever got that far. I think he simply said, "Who told you?" And that makes you wonder, because how come the defense attorney wasn't going to be told? So that is a problem. So the conversation, which apparently involved the judge, prosecutors, and a witness, reportedly included a witness admitting that he had killed somebody. And so if that's true, that would be an interesting thing to know. And so the attorney had said, if that's true, what this is coercion, witness intimidation, ex-parte communications that we have a constitutional right to be present for. And so he had asked for a mistrial. And it sounds like he's entitled to one. So the judge demanded to know how the attorney had gotten his information, and the attorney refused to disclose the source. The judge gave the attorney 5 minutes to reconsider, threatening with contempt of court, and then stormed from the courtroom. When the judge returned from storming out of the courtroom, and the attorney still refused to divulge the source, he was declared in contempt and ordered into custody. So the judge ordered the attorney to serve 20 days in the Fulton County Jail by spending the next 10 weekends there, reporting at 7 p.m. Fridays, being released at 7 p.m. on Sundays, beginning the Friday after the judge made this declaration. So after the ruling, the attorney asked if he's going to spend time in jail, could he spend it in the jail with his client? Sounds like a great guy. The attorney filed a notice of appeal of the contempt order to the Georgia Court of Appeals later that day. He also filed a motion asking the judge to reconsider and rescind the order of contempt or to grant him bond while his appeal is pending. The attorney's motion says that the judge and the prosecutors held a meeting with a sworn witness who had been granted immunity and who had been held in contempt after asserting his Fifth Amendment rights, and that's after he'd been granted immunity. The attorney's motion says he disclosed in court that he was aware of that meeting and had proceeded to move for mistrial. So the judge says that the attorney had information he shouldn't have had. The attorney says the information had not been declared confidential by a court order, that in finding him in contempt, the judge has imposed an illegal and inherently inconsistent punishment for this criminal contempt. And I agree with that 100%. So again, when you catch somebody doing something wrong, and you go, hey, that's wrong, and they go, how'd you find out? I don't think I need to explain that, do I? Well, I'll explain a little bit coming up, but still, that should be painfully obvious to you. The appeals court transferred the request to the Georgia Supreme Court, because they know it's going to wind up there, saying the court has the ultimate responsibility for determining who had jurisdiction over this case. And by the way, if something happens in court, let's assume something actually happens in court, and the judge is a witness to it, and he sees something happen, and he decides to impose punishment for that, you would think it might make more sense for another judge to step in and go, okay, let me handle this, and I'll make a determination whether or not the judge is right or whether or not the attorney is right, because the judge might be biased otherwise. So a date for that hearing has not been set. In case you're curious, back in May of 2022, a Fulton County grand jury indicted Young Thug, and more charges were added in a subsequent indictment in August of that year. The second indictment accuses Young Thug and 27 other people of conspiring to violate RICO. The rapper is also accused of participation in criminal street gang activity, as well as other charges. And so I'm not going to get into that because that's actually irrelevant to this case. So here's the thing. I'm very familiar with the laws of Michigan. I'm not so familiar with the laws of all other states. So I decided to grab the rules that judges must follow in Michigan, because these will be very similar to what the rules look like in other states. And in Michigan, it took me about 60 seconds to find this, and I was not even using word search. I simply went into the rules online and started reading, because I knew it would be near the top, what I was looking for. And so they refer to these as the canons, C-A-N-O-N, canons of rules that the judges should follow. Canon number 3. A judge should perform the duties of office impartially and diligently. A judge shall not initiate, permit, or consider ex parte communications, or consider other communications made to the judge outside the presence of the parties concerned, except as follows. And then there are exceptions. A judge may allow ex parte communications for scheduling, administrative purposes, or emergencies that do not deal with substantive matters or issues on the merits. And I'll give you an example. I showed up for a trial one time, and my opponent wasn't there. So I go into court, I'm talking to the court clerk, and the clerk goes, oh, there's a mix-up of some sort. And so the judge calls me into his chambers. And he goes, we're going to call your opposing counsel, find out whether they're not here. And so he dials and calls opposing counsel. Well, up to the moment he made that phone call, it was ex parte between me and the judge. But we didn't discuss anything substantive about the case. We simply were trying to figure out where the other guy was. Now, the judge could have come out on the bench, I guess, and made the phone call from the bench, and it was all on the record. But no matter how you slice it, at one point or another, there's just a moment where I'm talking to the judge and the other guy's not there. But we didn't discuss the case itself. So you can have it scheduling, administrative purposes, or emergencies, provided that the judge reasonably believes that no party or counsel will gain a procedural or tactical advantage as a result of communication. And the judge makes provisions promptly to notify all other parties and counsel for parties of the substance of the ex parte communication, and allows an opportunity to respond. And by the way, you'll notice that implies that even if you do an ex parte communication that's correct, you still notify the other people about it. A judge may obtain the advice of a disinterested expert on the law. Doesn't apply here. A judge may consult with court personnel whose function is to aid the judge in carrying out responsibilities. Not here. A judge may, with the consent of the parties, confer separately with the parties and their lawyers in an effort to mediate or settle matters pending before the judge. And then, of course, the last one is a judge may initiate or consider an ex parte communication when expressly authorized by law to do so. Wouldn't apply here. But getting back to D, which was with the consent of the parties, confer separately with the parties and their lawyers, it's not uncommon for the parties to come to court for a settlement conference and say, Your Honor, we're kind of stuck here. My client wants this, other side only pay this. And the judge will look at that and go, you guys are awfully close. Instead of having a trial, let's see if we can settle this right now. Do you mind if I speak to the parties separately? And they'll get permission. And you say yes, because the judge ain't going to discuss anything other than how we settle this case. So the other side goes in, talks to the judge, they come out, they send the other side in, back and forth. I've had that happen on dozens of cases. We're all aware it's happening. We're all participating in it. And we're trying to settle the case. The judge is acting like a mediator. He's trying to settle the case. But getting back to the fact that ex parte communications are wrong, so says the canons of judicial conduct. And again, I have a sneaky feeling that the same is true in Georgia as it is in Michigan. If it's not, someone let me know. But simply put, a judge should perform the duties of office impartially and diligently and shall not initiate, permit, or consider ex parte communications or consider other communications made to the judge outside the presence of the parties concerning a pending or impending proceeding. And by the way, you might wonder, how did the attorney find this out? And I have no idea. But keep in mind that if the judge met in his chambers, for instance, with an attorney and a witness, or with a prosecutor and a witness, specifically, a prosecutor is an attorney, but I'm saying let's say that the prosecutor and a witness go into the chambers of the judge. Well, the judge ain't the only person who knows that's happening, because the judge has a secretary usually who's out in office outside of his chambers or her chambers. And there's often law clerks and bailiffs and other court personnel wandering around, some of whom would say, oh, that's interesting. Prosecutor went in there with a witness, and they're talking to the judge with the door closed, and the defense attorney's out there. That would strike people as odd. And I'm going to tell you right now, I had a case years ago where a bailiff came up to me and the attorneys I was working with and said, by the way, while you guys are gone, you need to know what the other side was doing. It wasn't ex parte communications with the judge, but the other side had done something that we managed to do something about once we heard about it. And the point is that there's all kinds of people in that building who would know that this happened, quite likely. I'm guessing that there were other people who knew about that meeting other than the people who were in that room. And so the reason the judge is asking who told you, I'm guessing, is because he wants to yell at somebody and say, why'd you tell that to the defense attorney? And they're probably thinking because they deserve to know. Now, is it the secretary's job or a judge's clerk's job to tell the defense attorney that the judge is doing something wrong? I don't know that that's part of their job description, but actually it is part of their job, assuming that they're working in the courthouse in an attempt to do justice. So this guy, Brian Steele, the attorney on this case, is my hero because he's standing his ground on the concept of, I know something, I learned something, and I keep secrets for my client, and for whatever reason, he doesn't want to disclose how he found this out. He shouldn't have to. And the fact that he found it out is now embarrassing to a judge, but that judge is the one who should be looked at, not him, okay? They need to look at that judge and go, okay, explain to us now why you're meeting with the prosecutor and a witness who's been sworn, and you're discussing the case. Explain that to me. Because if they say, oh, we're simply explaining to him what happens if he continues to refuse to testify after being granted immunity. Well, they can explain that to him out in open court, or they could bring the defense attorney and say, do you mind if we discuss this with this witness right now in front of you? But when they exclude one party, it becomes X party, it becomes a problem. And this attorney, as far as I can tell, did nothing wrong. Now, it might be that somebody could say, oh, Steve, that's the problem. He discovered this through some nefarious, illegal methodology. I suppose that's possible. Anything's possible. But what we know right now is he discovered some information that he should have known. They should have told him. He should have been included in that conversation. He discovered that. And the response wasn't, oh, we screwed up. The response was, how'd you find out? So there you go. Young thug trial. Rapper's lawyer won't go to jail after the Supreme Court of Georgia granted bond. There will be a hearing somewhere down the road. But as you can imagine, now you want to talk about grounds for an appeal if this case doesn't go the right way. There you go. So Fox 5 Atlanta and everybody who sent it, thank you very much. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. I went to the doctor and he said, I have acute appendicitis. And I said, compared to who?